assault and battery comes up with maybe with somebody slapping another person. If somebody slaps another person against the person's wish or without the person's consent, it's assault and battery, and is an offense provided under the criminal codes. Now, the police have to look at the particular section prescribing or providing for this offense. He can come up with multiple counts, no doubt. It cannot be one count. The other one will stand. Because we are going to court where you must prove that this person committed this offense. And then proving criminal offenses, there are two major ingredients that must be proved. One is the intention or the mental element to commit this crime.
Okay.
The prosecution must prove that this person that committed this offense had the mental capacity, the mental ability, and the element to commit this offense, which in law is technically called mens rea.
Okay.
Now, the second element is the actus reus. That is the act or conduct of the offender. The prosecution must prove these two elements before conviction can be grounded. And where any of them is missing, where the prosecution cannot prove these two elements, definitely the defendant stands a chance of being discharged.
Okay.
So the prosecution has always duty to prove. And there is this English law, the English law that we practice, that says it is better that you release criminals than to convict one innocent person.
Yeah.
The reason being that if you release a criminal, maybe because there were elements of the offense that were not proved, there is every likelihood that this criminal may find himself back to be tried again, maybe by committing another offense. So that is why criminal offenses are strict liability offenses. It rests with the offender.
Okay. Is there a maximum?
And during trial, okay, go on.
No, go ahead.
Okay, now, so during trials, like the case you mentioned, case in point,
Yeah.
but we have not come to that. If there are contradictions, maybe amongst the evidence led between the witnesses, there are maybe contradictions, inconsistencies in their testimonies and all that.
Yeah.
You don't expect the court to safely convict on those contradictions or inconsistencies.
Okay.
The court cannot safely convict on them.
Okay. Well, for this case, that's exactly what happened because the judge literally pointed that out. Is there a maximum number of charges or counts that a person can be sued for?
There is no number. There is no exact number.
Okay.
What prosecutors do will be or are to frame up as many counts as they can or there are in the prescribing section of the offense. They try as much as possible to cover all the ingredients, all the particulars and details, and come up with those charges. So that, like I said, if one fails, the other one may stand. And we have found, practically in court, that sometimes the court may not be able to convict on one count, but may convict on the other counts. It happens.
Okay. Now, have there been cases where a person was wrongly charged? Not falsely charged, but wrongly charged. What they were charged with was not... It didn't align with what they were supposed to charge with. I'm trying to frame the question well so that maybe... the charge that took them to court did not best represent the offense that they committed.
Yes. There are times it may happen that way, but like I said, the prosecution must prove the charge beyond reasonable doubt, whereby a reasonable man will say, no, this man did not commit this offense. Must be proved beyond reasonable doubt. There will be no doubt. Once there is an iota of doubt in the case of the prosecution, it leads to only one thing, that is acquittal or discharge. And the defendant goes free.
Okay. Now, for this particular case, what is your take on it? Of course, there's already a verdict. It's been in court
There's
for...
yes, there's already a verdict. I've not seen the judgment, but one thing the public should know is that they are not. We have the public court, we have the court of law. Now, this matter took place in the court of law.
That's right.
The public court or the public opinion would have been that these people killed the policeman or the policewoman that it would have been convicted. No, don't conclude that way in court. You must look at the judgment. You study the judgment. And in studying that judgment, you would have seen that probably there may have been contradictions and inconsistencies in the testimony of the prosecution witnesses.
Yeah.
And so it will not be safe for the court to convict them at that point. It is not. Because the law is very clear on that. Once there are contradictions, those contradictions must be resolved in favor of the defendant. And you have to let him go.
Okay. So if I'm a plaintiff, should I, while filing a lawsuit, consider what I'm able to prove? Should that be a consideration? Or if I charge this person for this, will I be able to prove it in court, even though the person did it?
Yes, you have to. The investigating police officers who may have investigated this matter or any of these cases must look at the surrounding circumstances, must look at the offense committed and what came out of the testimony of the witnesses. Of course, the next statement to the police with witnesses and all that. But the complainant would have made statement to the police with his witnesses. Of course, the defendant would have made statement to the police with his own witnesses. Now, it is not the duty of the IPO to look at the whole testimonies, the whole evidence before him, and then come up with that opinion that there is an offense. I can charge this man maybe for committing murder or for stealing, and then prepare the charge along that line. After preparing it, he takes it to a senior police officer or a more experienced police officer who will also study the whole thing, look at the law, the section of the law upon which they are charging them, and then come to that conclusion that if we go to court, we may get conviction. Or at least come to the conclusion that these people committed this offense.
So what that means
you have to consider, like you asked, you have to consider whether this accused person or whether this suspect committed this particular offense, and whether I can be able to get conviction if I go to court before going.
Okay.
You know why? Because when you go to prisons, you see many people in that prison. I'm talking about Port Harcourt Maximum Correctional Center. When you go there, you see many people who are awaiting trial. They call them awaiting trial, male or female. When you get there, you see that a large chunk of them, a sizable number of them, did not commit the offense. They are being detained there. And these things are being caused by the police. Most of the time, they've not studied the offense alleged. These are the investigation they have done, and they charge the person to court. Something that would have been mere stealing, ordinary stealing. They may be charging the person for armed robbery, for robbery. These are higher offenses, for which only the High Court would have tried. And they will be there waiting for the advice of the Director of Public Prosecution. And time will go. Before you know, they've spent 3 years and upwards in detention. So the policeman and the IPO must be able to look at the evidence before him, what he has been able to investigate, what is on paper by way of the statement of both the complainant and the suspect and their witnesses, and then come to that conclusion that this is the offense. I will be able to charge them and get conviction. And where the evidence proves otherwise, maybe for a lesser offense, the IPO and the police officer should be able to charge appropriately on the offense, and not when an allegation was made that somebody has committed robbery or armed robbery. And there, in the evidence, you are seeing stealing. You still charge on armed robbery. No. Because that is what is tasking the correctional center in being overbloated with many detainees there.
Okay. Now, shouldn't there be repercussions for police officers who inappropriately charge? Isn't there a consequence?
Well, there is no consequence as such, except that when the matter finally is tried on the merits in court, the suspect will be discharged. Of course, they will not be convicted.
Well, that's not good enough.
There's no consequence.
That is not good enough.
It's not good enough for a system like Nigeria, because I think, if you ask me, but that is my opinion, there should be consequences.
There has to be.
And that would have put them on their toes not to be charging indiscriminately.
And so that also means that there are lots of people who may not go to court even though they've been offended, simply because they are not certain it can be proven in court.
The question has, I will need to learn a background before that. Like I said, a policeman or IPO, investigation police officer, who has investigated the case, looking at the evidence before him, and who have taken this evidence before a senior police officer, and they look at it together, they should be able to know, looking at the law, section of this law, maybe that if we go to court, we may get conviction. But sometimes they may not be really sure. They may not be sure of whether they can get conviction or not. And that is when, of course, they want to still move ahead and charge them to court, so that this matter will be tried by the judge or magistrate, who is an expert in adjudication.
Okay.
Policemen are not really trained to be adjudicators in matters of law or trial. So they may still need to go further. But where the evidence before them show, like I said, after investigation, that there is a prima facie case, they will have to charge that matter to court.
All right.
Police station is not a court where analysis are done in that manner that it can be done in court. So there are situations, like you asked, where they may hesitate and say, we are not sure we may get conviction, let us drop this one. It may happen.
Okay. Well, thank you very much, Barrister Emmanuel Okpala. We appreciate you for making out the time. Have yourself a wonderful day, sir.
Thank you. I wish you all the best. Thank you so much.
Okay. Well, that was Barrister Emmanuel Okpala, a legal practitioner and immediate past vice chairman of NBA Port Harcourt. I think that on some level, we can see the problem that our judicial system has. The fact that for certain things there are no consequences, you cannot expect and just hope that a system will fix itself if there is no framework. I know cases where the police has, of course, inappropriately charged. And it's not a question of allegedly. If you remember, the Ikoku 4, Chima Ikunado and the other 4, were they 5 or 4? They were wrongly charged. Yes, they were wrongly charged by officers of the Nigeria Police Force. And so if we do not have a system that checks and corrects that, you do not expect that to naturally change on its own. That somebody saw me stealing orange from the woman that sells in front of my compound, and when he makes his way to court, I see armed robbery. And maybe I'm exonerated. There is no consequence for the person who put armed robbery instead of orange stealing. I know that's not in the Constitution, but you get the point I'm making. There is a problem. There is a very big problem. And the fact that no one is asking these questions, well, I'm sure somebody is, but nobody has done anything about it, is an even bigger problem. So police officers can continue and know that nothing will happen. So when we say judicial reforms and every kind of reform, it's crazy how many times we're not looking in the right direction. But for this particular case, those 12